Mr. Marshall?
Good morning. May it please the Court. John Marshall for Bar Counsel. This is a bar discipline case that's before the Court on a reservation and report of a single justice. The Board of Bar Overseers has recommended that the respondent, Robert Lupo, be suspended for 2 years for misconduct in 2 unrelated matters. Bar Counsel is requesting that this Court order the imposition of an indefinite suspension for the misconduct. Our position is that a more severe sanction is required in this case because in 2 unrelated matters, the respondent engaged in improper business transactions with clients that were essentially predatory. What I mean by that...
Just so I can get my head on straight on an indefinite, after how many years can you reapply for if you get an indefinite?
5.
5?
Yes.
Okay.
The misconduct was predatory in the sense that in both instances the respondent was attempting to benefit himself at the expense of elderly, vulnerable clients. And it's the client's status as elderly, vulnerable clients which, as much as anything, underscores the predatory nature of the misconduct. Also, severer sanction is required because of the misconduct in the second case, which I think everyone concedes is the more serious of the 2 counts. In that case, the respondent induced an elderly aunt who was confined to a nursing home into selling her house to him for approximately $70,000 less than he knew it was worth. In other words, he defrauded his aunt of a large portion of the equity in her house. What I'd like to do in terms of discussing the facts and the sanction is start again with count 2 because that is the more severe.
Mr. Marshall, that's
Yes.
the second time you've said that, and I don't think that I necessarily agree that one is more severe or less severe. They are severe, correct?
Yes. Oh, both cases are very serious, and that's
Well, I mean,
in a
this
sense,
one
it's
happens to have, $70,000 perhaps, but in any case.
I say that, Your Honor, because it involves fraudulent misconduct directly against the client. That's the thing that jumps out at us in terms of analyzing the case for sanction purposes. But certainly I don't mean to suggest that the misconduct in count 1 was not serious or not severe. There are 3 things involved in count 2 that impact on the question of sanction. First of all, the respondent was acting from self-interest, as the hearing committee found. The fact of the matter was that the respondent operates a residential rental business as well as a law practice, and he had a business interest in acquiring his aunt's house and adding it to his inventory of properties. And in fact, that's what he did. After the transaction, he spent a little bit of money fixing it up and started renting it all the way through the time of the hearing. Secondly, the respondent's purchase of the house was an improper and unfair business transaction with a client, and it was unfair for a number of reasons, one of which was that he never advised her to seek the advice of independent counsel. But most importantly, it was unfair because it was for a consideration of approximately $70,000 less than the fair market value that he knew it was worth, and that's approximately 30% of the value. And that leads to the third consideration, and that is that the reason that the aunt engaged in this transaction with the respondent, even though there was that disparity, was because the respondent misrepresented to her that that's how much, that $170,000 was how much the house was worth. As the hearing committee found, he misrepresented to her the value of the house so he could purchase it for less than its fair market value.
I take it it's clear that the record is clear. I think it may actually be contested, but is the record clear? Was there a finding that he was in fact acting as counsel for
Yes.
his aunt, not just as a real estate advisor, because he, as you say, he also owns a real estate business?
Yes, he does. He's also a real estate broker, but and the respondent is arguing on appeal that there was insufficient evidence to establish that attorney-client relationship, but there was strong evidence that there was an attorney-client relationship. 3 or 4 months before the actual sale, the respondent and the aunt started talking about her potential eligibility for Medicaid should she go into a nursing home, and in fact, she went into a nursing home shortly after that. That was clearly legal advice. The sale of the house from the aunt to the respondent took place as a result of that advice.
So she wasn't consulting another attorney on the
No.
Medicaid, Medicare? all
No,
of those
she was
issues?
not. She was consulting with the respondent, and she was never advised to consult with another attorney on that point.
Is there any claim here, Mr. Marshall, and I'm not sure what a difference it makes, but that what was clearly at issue was, I take it, a perfectly straightforward attempt to have this elderly woman qualify for Medicaid, correct?
I disagree with that, Your Honor.
I thought
That was
I
part
thought
of
that
what
was
was
the
going
lead-
on.
Yeah,
But what else was going on was that the respondent was acquiring the house for his business.
Well, let me
And
put
so
it.
that's-
Let me put it this way, and maybe this. The sale of the house was part of the overall thrust of the advice that she should
Yes.
qualify for Medicaid, correct?
Yes, that is correct, Your Honor.
And
That
it is
flows
perfectly-
directly from that.
And it is perfectly clear that in order to qualify for Medicaid, she was going to have to spend down all of her assets, correct?
It was clear she was going to have to spend down her assets. There was some evidence.
Well, I'm just telling you, you have to spend down all of your assets, correct?
Yes, that's correct.
So, again, I'm not saying this in a defense, but one way to look at this is this money wasn't going to go to his aunt anyway. If the house was sold for $250,000, that was all going to go to the nursing home and to Medicare and so on and so forth. And if the house was sold for $170,000, it was going to go for all the money. She was not going to benefit in any respect from this. Am I correct?
That's possible, Your Honor. I don't know whether, to what extent she would have had, if she had more funds available to her, what other amenities she may have been able to
Okay.
enjoy while in the nursing home.
I was going to follow that up. The next question is, not infrequently, when one is a, quote, private patient, even if you can have Medicare, you are entitled to certain amenities, different diets, different, consistent with good medical
Yes.
care. Is there anything in the record to suggest that that wasn't play here?
There is nothing in the record. I agree with Your Honor that there is a general understanding that that is the case. There is nothing in the record supporting that in this case. I would like to point out that there are two problems.
But it could be argued that, and I'm just saying it could be argued that if the purpose of this was, all this money is going to go to the government anyway, so we might as well salvage a little bit of it now, you're cheating either the aunt or you're cheating the government.
Yes, that's correct, and that's one of the responses to that, Your Honor. There's another group of people that's potentially being cheated, and that is the aunt's other heirs. The aunt had a will that's in the record. She had a number of nieces and nephews who were to receive
right.
under the will,
Would she have been able to make gifts to charities?
I don't know. You mean for Medicaid purposes? I
Yeah.
don't know, Your Honor. I'm not-
Was count two the one that involved the application for a reverse mortgage?
Yes, that started the.
So she could have
discussions.
conceivably continued to live in her house and without going to the nursing home.
Had she not gone into a nursing home, yes, the reverse mortgage.
And that was the original plan, wasn't it?
Yes, exactly, and that was frustrated when she did go into the nursing home. There are two problems that I'd like to mention in response to your comments, Justice Marshall, and that is that this planning that may have been going on was not going on with her knowledge or consent. There was no discussion with her and with the other relatives
I
as to
understand.
whether
I
that was the appropriate way. The respondent simply misrepresented. And secondly, as Justice Graney points out, either the client's being defrauded or the government is being defrauded, and that was the response of the board hearing panel to the argument, and we certainly agree with that as well. Our position is that the misconduct in count two by itself supports a more severe term suspension, if not an indefinite suspension. And as we've argued in the brief, there are two cases, Voros and Pilavis, that we believe are very, very similar types of misconduct as the current case. Voros resulted in an indefinite suspension. Pilavis, which had other misconduct involved, also resulted in a disbarment. This Court's standard is the question of whether the recommended sanction is markedly disparate from comparable cases. Our position is that the 2-year suspension is markedly disparate from Voros and Pilavis, both of which justify a lengthier or indefinite suspension on count 1 alone.
Well, the board is sort of, in tune on these, matching up.
Yes.
What caused them, motivated them to give the recommendation of 2 years?
They said, in their opinion, Voros and Pilavis had more extensive premeditation, and that in some way in their minds the misconduct in count 1 was less sanctionable or less severe. And we disagree with that, as we've pointed out.
They said take a look at Tobin, correct?
They also referred to Tobin, and that's I think that case is not comparable. So I don't think that the sanction in Tobin really is helpful in terms of ultimately arriving at a sanction, because Tobin involved a lawyer giving advice to mortgage lenders, and the advice was wrong, and it assisted the clients in defrauding borrowers. There was no suggestion that the respondent was benefiting himself from this transaction, or knew that the advice was wrong, or knew that he was assisting his clients in a fraud. This is a much more direct case where the lawyer is engaging in a business transaction with a client, just like Voros and Pilavis.
Well, it is a little, you've got a hearing committee that recommends something less than you're asking for. You've got a panel, a review panel, recommending something less than you're asking for. You have the board itself recommending something less than you've asked for.
Yes.
There are a lot of people who bring a lot to the table who've looked at this very carefully. Why should we simply discard that thinking?
I understand the position you're taking. I would like to point out that this Court is the ultimate. The purpose of appellate review in a bar discipline case is to leaven the differences between cases, and it's very important to get judicial review in the event that this Court believes that misconduct is either more sanctionable or less sanctionable than the board may recommend. And I would also point out that the vote on this case was somewhat unusual. The vote was 5-4 in favor of a 2-year suspension, with the 4 dissenters favoring a more substantial
Mr.
sanction.
Marshall, let me ask you this, because I don't wish to minimize at all the impact on this elderly aunt, but as we know, there are many, many, many lawyers in this Commonwealth who help their elderly relatives. They often don't bill for those services. They often may be there may be other nephews and nieces around who disagree with the strategy that's been adopted. What's the bright line rule here?
In this situation, Your Honor, the first question I think you're addressing is whether there is an attorney-client relationship.
No, there's clearly an attorney-client relationship.
Okay. The bright line, Your Honor, is that there are ethical ways to accomplish the goals of estate planning in a family situation that do not include defrauding the person for whom you were doing the planning. And in this case, in our opinion, that's a very bright line. And it's, in our opinion, what takes this case out of an otherwise perhaps normal, perhaps ethical planning situation. In addition, the other factor that takes it out of that is the fact that the respondent is engaging in these discussions not only as a family member, but as a real estate business person who in fact wants the property for his own business. And that factor, if no other factor, should have compelled the respondent to advise the aunt to have another lawyer do this, to very simply get somebody else involved The respondent had the opportunity to do that because he actually had to go consult with another lawyer to figure out what the rules were, the Medicaid eligibility rules. He had the opportunity at that point to say to
Did he
that other
pay-
lawyer
is it-
or to the aunt, you
Does
deal
the
with it.
record reflect whether he paid the second lawyer? Or she?
The second lawyer was an associate in his office, and I don't believe there's any
Okay.
evidence on what the arrangement was there.
One final question. I think the appeal panel recommended that Mr. Lupo not be reinstated until he had made an accounting of all of his aunt's funds. That seems to be dropped out of the board recommendation. What's happened?
That was dropped out of the board's recommendation without comment, and so we're not sure why. In our brief, however, we have taken a different approach to the question of to the issue involved, and that is that we would prefer a suspension order in which entitlement to apply for reinstatement is conditional on restitution and not on accounting. We look at it this way, Your Honor, and that is that if you go back to 1998, the house was worth $240,000. The question of accounting for her assets goes to the question of what happened to the $170,000. The evidence is clear that the respondent took that $170,000, put it in some bank accounts, managed it, spent it down until she became eligible for Medicaid. The question of restitution.
So there is no need for an accounting.
Exactly. Relatively speaking, we're much more concerned about restitution. As we pointed out in the brief, one of the main differences between this case and Palavis and Voros is that the respondent benefited himself immediately from this transaction. He got a house that was worth $70,000 less. I'm sorry, that he paid $70,000 less than it was worth, and he's used it in his business, presumably for profit, although that's not specific on the record. It is unseemly that that is happening, and we believe that restitution is a traditional concept and question in bar discipline cases. That similar type of order was entered in the Ferris case, and we're asking for it in this case as well.
Thank you, Mr. Marshall.
Thank you very much.
Mr. Foy? As I understand it, you're going to have 14 minutes, Mr. Foy.
Or thereabouts, Your Honor. We're going to, we have Mr. Kelly's just going to speak briefly to certain procedural matters when I'm finished. I do want to begin with count one, because I think that it's important to understand that the supposed repetitive pattern of predatory behavior didn't exist. In count one, first of all, to set the stage, to my knowledge, a conflict of interest case in this court, the most significant punishments have been matter of Pike and matter of Wise, both of which were 6-month suspensions. The hearing committee represented double that. The appeal panel doubled it again. And Bar Counsel, in reliance upon some precedents that we argue in our brief, are completely off point, primarily conversion cases, has tried to argue for the indefinite suspension. But I think the linchpin of the case and the reason why everyone at every step of the proceedings departed from this court's precedents is the fact that it perceived this as being a pattern of behavior. In fact, the 5 sisters that Mr. Lupo was working with in 1996 were sophisticated business persons. They entered into 2 listing agreements with him, one in March and one in June. The hearing committee specifically found that the June listing agreement was fair, that it was reasonable, that it was entered into with the advice of independent counsel, namely the daughter of one of the aunts, an attorney Pendergast. And so the conflict of interest we are talking about existed for precisely 3 months. This conflict of interest consisted of signing a listing agreement which was in every respect, material and immaterial, identical to the listing agreement that the attorney Pendergast and her clients ratified in June, with one single exception. The amount of the commission was different. And the hearing committee, in footnote 6 of its findings, specifically found that the 10% commission that was in the March listing agreement was fair and reasonable, just as it had implicitly found the 8% commission that was in the June listing agreement was also fair and reasonable. This, I put to the court, is not the stuff of which a substantial period of suspension is made. And I think if this court consults matter of Lake, a case which we hammered at in the courts below, in all of the proceedings below, and which we mentioned before this court, and which Bar Counsel never, in any writing that I am aware of, has ever addressed the applicability of. Matter of Lake is very close to this case, and the attorney in that case received an admonition.
So what penalty are you seeking here?
Here we are seeking, if there was an attorney-client relationship in count 2, then we think that the suspension is appropriately one of 6 months. If there was no attorney-client relationship, we think a lesser or no suspension at all is appropriate. And let me move directly to count 2. There are some other points made about count 1 in our brief, but I think that we will rest on the brief in that regard. Let me put 2 hypotheticals to the court. Hypothetical 1, Mr. Lupo.
Before you get to that, Mr. Foy, was there any, there's no question that your client provided legal advice to the sisters, as I understand it?
Yes, he had an attorney-client relationship with them. There's no question about that.
And he was also acting as their broker?
He was, Your Honor, for a period of 3 months.
And there was no, and what am I supposed to do with that? Because as I understand it, he didn't obtain their written consent and so on and so forth.
That he did in fact violate the disciplinary rules, and that the appropriate punishment for doing so, because there was no harm befell the sisters in those 3 months, the appropriate presumptive punishment, as it was in matter of Lake, is a private admonition or at most a public reprimand.
And so that's the only, your position is that's the only basis of any sanction?
Yes, Your Honor.
Okay.
Yes. There was also an issue about Mr. Lupo. Attorney Pendergast complained to the Board of Bar Overseers about Mr. Lupo. Mr. Lupo, subsequently, there was litigation between himself and his clients, and Attorney Pendergast was named as a party for having done that in bad faith and, in effect, as a negotiating tool, knowing the sisters, when they left Mr. Lupo's representation, refused to pay him. By the way, the litigation itself, as between the clients and Mr. Lupo, wasn't charged in the petition for discipline, wasn't part of the petition for discipline. We are saying that the Board's findings are erroneous as a matter of law when it finds that naming Attorney Pendergast as part of that lawsuit was a disciplinary offense. If for no other reason than the fact that the infraction that Bar Counsel challenges, Section 40, SJC Rule 401, Section 9, doesn't say it's a disciplinary offense, and no precedent in this Court has ever said it's a disciplinary offense. Mr. Lupo had independent counsel that made a good faith argument that Attorney Pendergast wasn't immune. And Judge Kottmeyer in the Superior Court found that the suit wasn't frivolous under 231-6F. Many times Bar Counsel has come to this Court brandishing findings of the Superior Court that there was a violation of Rule 11, that there was a violation of 231-6F. This time Mr. Lupo has the opportunity to brandish that finding. He was not acting in bad faith. It has been so found. To move on to count 2, this was an unfair business transaction. That's how Mr. Marshall put it, if there was an attorney-client relationship. But let me, again, move to the 2 hypotheticals I was going to pose to the Court a moment ago. Let us say that Mr. Bar Counsel comes knocking on Mr. Lupo's door, and Mr. Lupo says, yes, I was her attorney. Yes, I did her estate planning. We agreed on a below-market transaction of $70,000 because I had been working for her for years, literally years, and never been paid for any of my services. And for the next 5 years, I continued to administer the money that we received from that sale of that house, and we knew that I was going to do that, and I was acting almost in a sense as a trustee. I spent 5 years, the checks are on the record, the accounting's on the record, and I did that for 5 years, and we agreed that that's what I was going to do.
Did you declare that as income on your taxes?
I don't believe he did, Your Honor, but he's declaring the income on his taxes that he is receiving from the rental of the house, and he is not deducting it as a cost. I'm not sure where there's a business involved that would be a material distinction. And I am making a hypothetical. And if Mr. Lupo had said that, I dare say that Bar Counsel's remedy at that point is to go home. I don't
Would
think
you have to declare? Would you
That's not our
have?
case.
No, it isn't our case, Your Honor. That is not. That is absolutely true. But I'm submitting that the distinctions between that case and our case don't justify indefinitely suspending a man from the
Well,
practice
first of
of
all,
law.
we don't know how many hours. We don't know, what the representations were. Is his aunt is no longer alive, or she's still alive?
His aunt is no longer alive, Your Honor. He is, in fact, the administrator of his estate, of her estate, and so appointed by the probate court without objection from any of her relatives. And I dare say that we do have on the record, in the form of Exhibits 296 and 297, a listing of all of the checks that went out. And I think perhaps the checks themselves. And it is a very large number of transactions, as one might expect from spending down $170,000. Mr. Lupo was his aunt's lifeline. She was the person that he was the person that she relied upon for literally everything in his life. No doubt
Mr. Kelly, Mr. Foy, I'm sorry. Let me ask you this. Assume that there was, in fact, whatever the difference is, $70,000 or whatever the alleged defrauded amount, was in fact merited for past payments, for past services rendered without payments. Don't we have here a problem with respect to the dealing with the federal government in this sense, that is my very inexpert understanding of the Medicaid rules is in order to qualify for Medicaid, you have to spend down your assets, but there has to be some, but Medicaid can look to see in what respect the assets are being spent down. Some qualify, some don't qualify, correct?
Yes,
So if you have side deals between an attorney and his client, or a non-attorney and his client, where essentially you are shielding from review, $10, $30, $40, $50, $60, $70,000, doesn't that in itself raise a concern or a problem?
I think, Your Honor, that where it is agreed in advance by the attorney and the client on, let's say, a flat fee, such as here of $70,000, where the agreement is reasonable at the beginning because neither the attorney nor the client knows whether that $70,000 is going to cover 2 years, 5 years, or 10 years of legal services, and where the agreement between the attorney and the client is such that the fee is earned at the time it is paid, and there is therefore no residuum to give over to Medicaid, I doubt if the government would be in a position to have an issue with that.
But as a general matter, we have a whole series of constructs that say you have to sell at fair market value or for considerable. I mean, here essentially what you're saying is the fair market value, at least in theory, was whatever it was, $250,000 or $240,000. But we didn't sell the property for $240,000 because, in fact, it was agreed that I would pay only $70,000. I mean, as a general matter, the courts don't look very kindly on those to say there was the consideration listed is $170,000 when it's not. It's $240,000, of which $70,000 can be taken to pay for attorney's fees.
That would certainly be that would probably be a disciplinary violation as well, Your Honor. It wouldn't be an indefinite suspension or a 2-year suspension or even a 1-year suspension, I venture. I think that concealing that perhaps from Medicaid, and I say this as one who has no expertise. I have elderly parents, and this case scares me. I fortunately have no expertise.
Could I ask you, we're talking about a hypothetical that is not this case.
No, it isn't, Your Honor, but I think that, I'm sorry.
And so, don't we have to deal with this case and these findings, which include a misrepresentation to his aunt that $170,000 was a fair market price for her house at a time when Mr. Lupo knew that her house was worth a lot more than that, and he was going to, in essence, benefit from and pocket that difference. And you know, this was not explained to her as attorney's fees or Medicaid or whatnot. It was just an out-and-out misrepresentation.
Your Honor, I think that the hearing committee's finding in that regard is questionable and needs to be seen in context. And the context is that because this was a business dealing with his aunt, and he looked upon it that way, that the misrepresentation was not of the – he did not see this as a relationship that was colored with fiduciary overtones, and to the extent that he did not see it subjectively as – I think the nature of a conflicts case, the point I'm trying to get at indirectly is that the nature of a conflicts case is that the attorney prefers his own interest to that of the client. When he went out and got the appraisal that said it was worth $170,000, that appraisal appraised it as a two-bedroom house. When the Bank of New York went out and had it appraised, they appraised it as a three-bedroom house for $250,000, and that's what he applied for as the bank loan. But that is the nature of a conflicts case, and it is different than that of a case of outright theft, if for no other reason than the fact that no one here can say with any degree of certainty that his aunt would not have agreed to the transaction, even if an attorney had been gotten for her, and even if it had been explained to her. There would have been nothing. I think there's no ethical impediment to Mr. Lupo having said to that independent attorney, or Mr. Lupo's attorney saying to that independent attorney, he's been with her for 5 years, and if she ever wants to see him again, she will sell this house at $170,000. And I think it would have been a morally reprehensible thing to do, but I don't think it would necessarily have implicated directly the attorney discipline rules. The Bar Counsel charged it as a conflicts case. He prosecuted it as a conflicts case. Now that we're at the penalty phase, or even before when we were at the penalty phase, Bar Counsel wanted to bring this into the not just even a misrepresentation case, but really a case of outright theft. And I think that is where fundamentally the tribunals below and Bar Counsel errs, because it is ultimately a conflicts case. One in which I might add, the attorney didn't even perceive the conflict, because I think it was at least reasonable for Mr. Lupo to believe that he was not acting as his aunt's attorney. He had the business, the real estate brokerage, and all the rest.
Thank you, Mr. Foy.
Thank you, Your Honor.
Mr. Kelly, you have a very brief 1 minute.
Thank you, Your Honor. If it pleases the Court, my name is Brian Kelly, and I just have a moment. I actually am planning on just to submit on brief, and I just want to thank the Court for allowing this highly unusual proceeding, but where this is a de novo review, and as Justice Cordy and Chief Justice Marshall have raised the question of why this amount of sanctions, we just want to bring the Court's attention to what we considered an unusual procedure that may or may not give some guidance to the Court as to perhaps why the sanctions were a little more substantial than the respondent would suggest they would be. And again, I will submit on brief. I did want to just call the Court's attention to one other piece of information that is included in the brief but was not pointed out on addendum page number 9, going to the point of where there was a conflict or a antagonism between Mr. Lupo's counsel and one of the board members, just to show the egregiousness of the antagonism, if you will. Not only, as I said in the brief, did he Mr. Lupo's attorney misname the case to seemingly bring to light the fact that the board member was one of the defendants in the case, but also mentioned that it was a legal malpractice action, further exacerbating what we consider the stirring things up. And the fact that it was the only case that it was actually a pending Superior Court case. There's no reason to bring that up as precedent. And with that, I will submit and thank the court for their
Thank
time.
you, Mr. Kelly.
Commonwealth does not represent the wealth.